I hope all of you are in good health and safe. So, with this positive note, let us start. Today's topic is kinds of companies. Different kinds of companies are formed for various purposes. They may broadly be classified on the basis of mode of incorporation, on the basis of number of members, liability of members, control, ownership, and on the basis of access to capital market. There are some other companies also, so we will talk about it. So let me start with the classification of companies on the basis of mode of incorporation. On the basis of mode of incorporation, the companies may be classified into two categories. The first one is unincorporated or unregistered companies, and the second one is incorporated or registered companies. So, what is an unincorporated or unregistered companies? Any entity or organization formed but not registered under the Companies Act 2013 or under any previous company law may be called an unincorporated or unregistered company. The expression unregistered company includes the following entities: any partnership firm, any limited liability partnership, any cooperative society, any society, or any other business entity. So, all these entities may at any time apply for registration under the Companies Act. So, the second category is incorporated or registered companies. A statutory company is one which is incorporated by a special act of legislature, that is by the act of parliament or state legislature, such as Reserve Bank of India, Life Insurance Corporation of India, State Road Transport Corporations, etc. are examples of statutory companies. Then we come to the registered companies. A registered company is one which is formed and registered under the Companies Act 2013 or under any previous company law. Such a company comes into existence when it is registered under this act. Under this act means under Companies Act 2013, and a certificate of incorporation is issued to it by the registrar. The second classification of companies is based on number of members. So, on the basis of number of members, three kinds of companies may be registered under the Companies Act. Number one, public company. Number two, private company. And number three, one-person company. So, the minimum number of persons required to form a public company is 7. But there is no such restrictions on the maximum number of members. A public company is defined in Section 2, subsection 71 of the Companies Act 2013. So, according to this section, a public company means a company which is not a private company and which has minimum paid up capital of such amount as may be prescribed. Earlier, the minimum paid up share capital requirement was rupees 5 lakhs for the formation of a public company. But this requirement was removed by the Companies Amendment Act 2015. So now we move on to the next category, that is private company. The minimum number of members required to form a private company is 2. And the maximum number of members must not exceed 200. It is defined in Section 2, subsection 68 of the Companies Act 2013. So, according to this section, a private company is one which has a minimum paid up share capital of such sum as may be prescribed. Earlier, the minimum paid up share capital to form a private company was 1 lakh. But this restrictions was removed by Companies Amendment Act 2015. There are some restrictions on a private company, which is put by its articles of association. So the first restriction is that a member of a private company cannot freely transfer his shares to an outsider. The second restriction is that the section limits the maximum number of its members to 200, excluding the present or past employees of the company. And the section also prohibits any invitation to the public to subscribe for any shares or debentures of the company. That means it cannot give invitation to the general public to subscribe for its securities. So after private company, the next company is one-person company. The concept of one-person company is a new concept which has been introduced by the Companies Act 2013. It is defined in Section 2, subsection 68 of the Companies Act 2013. According to this section, one-person company means a company which has only one person as a member. There are some important points regarding one-person company. The number one important point is that only a natural person can be a member of a one-person company. The second important point regarding one-person company is that the one-person company can only be formed as a private limited company. The third important point regarding one-person company is that the words one-person company shall be mentioned in brackets below the name of the company wherever its name is printed, affixed, or engraved. And the memorandum of one-person company shall indicate the name of other person who shall become member of the company in the event of death or incapacity of the single member. The third classification of company is based on liability of members. So on the basis of liability of members, the companies may be classified as companies limited by shares, companies limited by guarantee, and companies with unlimited liabilities. So a company limited by shares is one in which the liability of members is limited to the extent of nominal value of shares held by them. So if the shares are fully paid, that is, all the amount of share has already been paid, then the liability of the members is nil. And if the shares are partly paid, then the liability of the members is limited to the extent of the amount which remains unpaid. Let me give you an example. So Mr. A was a member of a company limited by shares, and he purchased 100 shares of rupees 10 each. Total value of shares is rupees 1000. Rupees 8 on each share has already been paid by him. That is 800 rupees 800 has already been paid by him. So in this case, Mr. A's liability is limited to the extent of rupees 200. That is the amount which is unpaid on the shares. Next company. A company limited by guarantee is one in which the liability of the members is limited to such amount as he undertakes to contribute to the assets of the company in the event of its being wound up. So the amount of guarantee is fixed in the memorandum of association of the company. Companies limited by guarantee are generally non-trading companies, and they are not formed for the purpose of earning profits. Such companies are formed to carry charitable activities such as to promote art, sports, science, and culture, etc. So we come to the third category. So companies with unlimited liabilities. An unlimited company is one in which the liability of the members is unlimited. It means the members are also personally liable for the payment of company's liabilities. So, in the extent of winding up of a company, if the assets of the company are not sufficient to pay its liabilities, then the private property of the members can also be utilized for the payment of company's liabilities. So the rest of the classification of companies will be uploaded in my next video. So till then, be in good health and safe. Thank you very much.